Hello everyone, welcome to Court with Krissy and Linda. This is the crazy court you didn't catch. And there's a warning. I'm an animal lover. The last case, it's an animal lover. Hide your kitties, hide your doggies, and hide your sheep. I'll give you a warning. I hope you like it. Court with Krissy is now in session.
Anderson, ma'am.
Thank you. Say your name one more time, please.
Martell Anderson, ma'am.
Thank you. Calling
Yes,
case
ma'am.
number 240-611-9601. People of the state of Michigan versus Dion Martell Anderson. Counsel?
Jessica Scheib on behalf of Mr. Anderson, who has full reading, understands his constitutional rights, and stands beyond.
Thank you, counsel. The court notes formal reading has been waived and enters a not guilty plea on Mr. Anderson's behalf. Are the people entering an appearance on People versus Dion Anderson?
Your Honor, this one is Mr. Reagan's. Let me see.
I apologize, Your Honor. I didn't have my camera or speaker on. I was looking at the report. Samuel A. Ragnan.
No problem. Thank you. This is an alleged, looks like a fight between brothers. Weapon alleged is a tactical knife. Charge here is felonious assault. Arguments as to bond, please.
Well, Your Honor, it also is when he punched his son in the mouth with his fist, and he also pulled out the knife, and then he threatened to kill. I'll kill all of you is what he said. And then when he's being arrested and taken out by the police, he makes reference to, I believe, they believe at least, that he was going to do something in nature, I think, to in a violent way of some sort, what they said. So
well, wait a minute, because he's only got one charge of felonious assault.
Right.
But it is as to two complainants with the knife. Okay, go ahead, please.
Okay, well, he's got 2 felony firearms, an attempt CCW, and an A and B conviction. The last one was in 2011. But, Your Honor, I'm sorry, he had 2 DVs, domestic 7, 13, 18, and a child abuse, and another domestic violence. So I think he's got arrested even for violence in the past, and I'm concerned about the welfare. Does he have a place to live? If he has a place to live, maybe Ms. Scheib can help us. And if he has no contact with them, then I would agree to a $35,000 personal bond.
Okay, thank you.
So we wouldn't be objecting to the personal bond, of course. And Your Honor, Mr. Anderson has 17 kids. He lives with his fiance in this house. He told the mother of his kids and these kids to come stay with him because they didn't have another place to stay. I wasn't there, but I'm assuming when you combine a bunch of people in a house and kids and all and their dogs, these are, like the court said, 2 brothers fighting. This is their father. The complaining witness listed here is 20 years old. This isn't, a child. I don't have any injuries, anything like that, any witnesses, anything like that here. He's not on probation or parole, nothing pending. His priors are from 2011. We don't believe he's an assaulted person, and he doesn't have any flight risks. So the only thing is, I would be asking that Mr. Anderson be able to go back to that address with no assaultive contact. If the court is not inclined to do that, then I guess Mr. Anderson is going to have to find another place to go. But this is his home. This is where all his, this is him and his fiance's home, and this is where he allowed them to come and stay with him. And brothers got into a fight, and the dad tried to, allegedly take control and end the fight. And now he's the one standing in front of you in jail. So we wouldn't be objecting to a personal bond. But if there's any way he can have no assaultive contact in his home, Your Honor, that's what we would be asking for. If the court is not going to release him, if he's going to go back there, then Mr. Anderson's just going to have to find another place.
Thank you. Mr. Ragland, did you tell me there are previous domestic violence and child abuse convictions or charges?
No, not convictions, arrests, and charged with these charges, but then subsequent dismissals. Back on 5/2/23, domestic violence dismissed, 7/13/18, 2 counts of domestic violence dismissed, child abuse also dismissed. I mentioned that for the reasons, Your Honor, that obviously he was arrested for situations that did not result in convictions, but I felt that they were necessary to let you know.
Well, I do agree that they support your request for no contact here, not no assaultive contact, but a strict no contact in this case. Bond will be set at $50,000 personal. Mr. Anderson, you are not to have any contact or attempted contact with the complainant in this case. That means no verbal contact, no written contact, no contact through third parties or social media. Any attempted contact will be considered a violation of the conditions of your bond. That also means that as long as that person still resides in the household where you were residing, you cannot go back there. All right? No contact means no contact. We'll have to find someplace else. All right, thank you. January 9th, you're welcome. January 9th for probable cause conference, January 16th for preliminary examination. Both of those are in front of Judge Taylor. And that does extend to both of the complainants in this case, both Devontae and Dion Anderson. All right? Okay, thank you.
Yeah.
Oh, where did Mark go? Okay. Next matter is 24 CRB 531, State of Ohio versus Brianna McGee. Ms. McGee is present with counsel, Mr. Taylor. Mr. Cox here on behalf of the Law Director's Office. And we're scheduled for a change of plea to a charge of theft today. Ms. McGee, you understand that a guilty plea is a complete admission of your guilt?
Yes, sir.
Okay. And you did sign this change of plea form? Okay. Did you understand it?
Yes, sir.
All right. You understand you're waiving your right to a trial, either to a jury or to the court.
Yes, sir.
At a trial, you'd be able to call witnesses to testify on your behalf, subpoena witnesses to force them to appear here and testify, and present evidence in your own behalf. You understand you're giving up those rights today?
Yes, sir.
You also understand you're giving up the right to question any witnesses the state would have against you.
Yes, sir.
And finally, you understand you're giving up the right that the state prove beyond a reasonable doubt you did in fact commit this offense.
Yes, sir.
Mr. Taylor, you're going to have Mr. Cox recount the facts.
Your Honor, thank you.
Based on that, I'll accept Ms. McGee's guilty pleas being voluntarily and intelligently made, knowing what her rights are. Find her guilty of theft. Mr. Cox, you have a recommendation today.
Yes, Your Honor, thank you. This was a Home Depot theft. Our recommendation would be 30 days. This is considering the nature of the theft here, approximately a little over $700 in value, and considering the prior theft or theft adjacent convictions. So that's our recommendation, 30 days of flat time. Thank you, Judge. There's no restitution requests either.
Okay. Mr. Taylor.
Thank you very much, Your Honor. Ms. McGee is present here today to take accountability for actions. She does currently work part-time at McDonald's that's located in Columbus. She has indicated to me she has 4 young children. She does assert that she's having surgery today at OSU in Columbus at 1 p.m. She has an issue with her shoulder. Ms. McGee is asking to be placed on a period of probation and supervision. If the court would not deem that to be appropriate, she would be asking for a jail sentence on the minimum range. And as she is having surgery today, she would ask for a report.
Ms. McGee, would you like to say anything today?
Not really. I take accountability for what I did. I've definitely learned my lesson, and I've been making the proper things to change my life around.
Okay. Where are you having surgery today?
OSU.
Okay. You have some documentation about what's going on with you today? No? Okay. Great. Okay, so what do you, so on your shoulder? What kind of surgery is it?
I'm guessing they're gonna probably replace.
What you have? You just have an appointment today? You don't have surgery today?
Yeah, no, I have a surgery today.
You don't know what the surgery is?
Yeah, it's a replacement. Yes.
They're replacing.
Yeah.
Your. Okay. All right, unopposed court costs, 30 days in jail. Mr. Tabler, I'm assuming you want to report then?
Yeah, sure.
Okay.
If the court would allow it.
Mr. Cox?
Your Honor, I don't have any necessarily reasons to doubt, would like some paperwork, but if she's representing that to the board with the understanding that could be used as a contempt motion or things of that nature and those consequences, I don't have a problem with the report date. Thank you.
Thank you.
Krissy?
Explain, if I may. Morning, Your Honors.
Morning, Mr. Dill.
Morning, Ron, how are you?
If I may explain, People versus the case of Stephen Cole, case number 24-4401 FY. This is the time and place for a probable cause conference. They're generally on the pretrial docket, so I don't know if the court would receive them. But because Mr. Cole is present in the Antrim County Jail and he is representing himself, and it is a felony case with sentencing and another felony case next week, I'd like to place the probable cause conference on the record, just so that there's no misunderstanding with respect to the offer, and that the document for the conference I'm going to deliver to the bailiff, Deputy Hayes, and he's going to take it over.
Okay, so where's Mr. Cole? Can you hear us?
Yes, I can. Can you hear
Okay,
me?
so right, and so you understand the nature of this proceeding today?
Not particularly, but go ahead.
Go ahead, Ms. Truesdale.
Thank you, Your Honor. I think I'm going to approach the podium so we can have good hearing. If I may, I'm going to read the probable cause conference document into the record. Mr. Cole, are you there?
Yes, I am.
Okay.
Good.
The probable cause conference document states that the parties, that would be you and the people, certify that the probable cause conference was held. Discussions as to possible plea agreements were completed. Also discussed were matters pertaining to stipulations and procedural issues relevant to the case, and discussions regarding bail and the opportunity for you, the defendant, to petition for a bond modification. Now, generally, this is conducted with your attorney, but because you're representing yourself today, I wanted to advise you that the plea offer that has been made is no offer, and now is your opportunity to raise any issues petitioning for a bond modification. So that is the extent of my involvement in this, and I have a document here which I've signed, and I'm going to provide to Deputy Haynes.
All right, thank you.
Thank you.
Ms. Truesdale. So any questions, Mr. Cole?
I have no questions, other than, did you get my paperwork?
I don't have any paperwork here, sir.
Okay, well, I'll stand on my paperwork.
Okay, you do that, and we'll see you next time. Thank you.
Say it, bye.
Hi, what's your name, sir? All right, thank you. Calling case number 240-609-4401, people of the state of Michigan versus Leonard Turner, counsel.
Jennifer Douglas for the people, P72748.
We'll bring it on behalf of Leonard Turner, Your Honor, waive the formal reading, stand mute. He has been advised of his rights.
Thank you, counsel. The court notes formal reading has been waived, enters a not guilty plea on your client's behalf. I see only one prior conviction here from, looks like 24 years ago. Little more than that. Charge here is felonious assault. Positions as to bond, please.
Your Honor, the people are asking for a bond of 5,000 cash or surety with a tether to ensure no contact. Here, there is the prior, but that prior is felonious assault, the same thing he's charged with here. He does have a 2006 domestic violence. That's against his wife at the time, who I believe is still his wife now. Your Honor, we have concern here in that there's a weapon involved, that there seems to have been no provocation, and Your Honor, that Mr. Turner allegedly said that he would stab this complaining witness to death. While we know that Mr. Turner is an elderly man, the victim, his 18-year-old grandson, our concern is if Mr. Turner goes back to this location, the grandson's in a position of possibly having to fight his 79-year-old grandpa if something happens again. And that's not going to be a good outcome. That's not something we want to have happen. It's not clear why this would have happened, but Your Honor, there is an assault of history there, even if it's an older assault of history. So Your Honor, I would note that while the report indicates officers had trouble following up contact, there is a December 7th note in the file from the APA who charged it, saying she spoke with the grandson and he wants to move forward. So the grandson does plan on moving forward with this, and we have concerns for his safety. We have concerns for Mr. Turner's safety if he's threatening to stab people. So Your Honor, we're asking for 5,000 cash or surety with a tether.
So,
Okay,
Judge,
Mr. Reagan.
with all due respect, Judge, we can make an argument for anything. I understand that this is a fact pattern in an investigator's report. My client is 80 years old, almost retired from Chrysler after 35 years. This 18-year-old wants to bring a girl in the house. My client says, no, you can't bring a girl in my house. He gets mad, calls the police. My client never had a weapon, Judge, and it's my client's home, but he's trying to help his grandson and the grandson gets mad and tries to flip it and call the police on his 80-year-old grandfather, which I think is ridiculous. And I understand, the people have a position, but we have a position too, Judge. I'm asking for personal. The only issue, Judge, is I'm asking the court to consider this. I'm asking for no assaultive contact, and this is why. My client's 80. It's his home. He's lived there his entire life. He's worked hard at Chrysler. For him not to be able to go back to his own home, Judge, I think is crazy. But I do understand there is a case that the Wayne County prosecutor, whoever signed the case, I don't know who they are, but it's here and we got to deal with it, Judge. So, okay, Miss, 6P now. Okay, so I'm asking for no assaultive contact, Judge, so he can go back to his house. That's my request.
Thank you. This is a case where the investigator's report appears extremely one-sided to me. I've got a 79-year-old man whose last assaultive conviction, felonious assault, was from 24 years ago, 24 and a half years ago, really. And then I'm hearing about a misdemeanor from 2006. I've got complainants here who don't, there's a question about how cooperative they are. There's an allegation that a knife was used, but no knife was found. This is the defendant's home at 79 years old. We're dealing with not a minor, we're dealing with an 18-year-old. And if 18-year-olds feel unsafe in the place where they're living, you know what they can do? Walk right out the door. I've raised a couple of them, all right? They are free, they are adults. I'm not going to prevent Mr. Turner from going back to his home, even on the basis of this report. Bond is set at $5,000 personal. Next court date. December 16th for probable cause conference, December 20th for preliminary examination. They're both going to be in front of Judge Taylor. Mr. Turner, you're not to purchase or possess any firearms or other dangerous weapons during the course of your bond. Thank you.
Thank you, Honor.
Calling 24141779FY.
Morning, Your Honor. Whitney Level P58914 on behalf of Juan Terrell Lane. Your Honor, this date and time set for an arraignment. With regard to this case, my client, I've explained to him what he's being charged with. He does not need the formal charge read over the record. He pleads not guilty. We ask if the not guilty plea be entered. Ask that the court set this matter for a probable cause conference, for by client, a court-appointed attorney, and we can discuss bond at the appropriate time.
All right, Lane, state your name for the record, please.
Juan Lane.
Did you talk to Mr. Lemelin today?
Yes.
Did he go over your rights with you?
Yes.
And all of those rights?
I'm sorry, what was that?
Do you understand all of those rights?
Yes.
Right. Do you have any questions regarding those rights?
No.
Right. I'm going to enter a not guilty plea for purposes of arraignment at this time with regard to the felony case. And it looks like we've show causes on another case, but with regard to the felony case, with regard to bond, Mr. Lemelin.
Your Honor, I'd ask that the court consider a personal bond or something that my client can reasonably obtain. I obviously don't know any of the facts of this case. He does not have a problem with the no contact with the jackpot pawn. He does, he's a father of one child. He does have a good job. He sells newspaper subscriptions, and he supports himself doing that. He's grown up in Detroit. He lives in the area all his life. He does travel out of state sometimes to sell for his work, Your Honor. So I'd ask the court that any bond provision allow him to travel out of state if necessary. He tells me he does not have any other cases going on aside from the 2 cases that he's being show cause for owing money.
Yeah. By the way, why did we do a misdemeanor form?
I did a misdemeanor form because of show causes. I didn't know if the court was going to.
No, but thank you. Yeah, we'll just carry them over with the felony one.
Okay.
Okay. I just wanted to check and make sure I wasn't missing something. Okay. Sir, my biggest issue is you just showing up to court. Are you good? What goes on with that? Because it looks like you have a lot of failure to appears. Sir, how do I get you to show up to court?
Mr. Lane, can you hear us?
Oh, yes, I can hear you. I know she was speaking to me.
Yeah, Mr. Lemelin always shows up to court. I need you to show up to court. You're not my case. I'm sending you to another courtroom. And you have failure to appears on this for not showing up for owing fines and costs. So how do I guarantee you're going to show up?
I can just tell you I'm going to show. I don't know how you would guarantee it. Serious matters.
On these other ones?
Negligence, I believe, and not misguidance. I'm actually not sure. I was moving around a lot, so a lot of my addresses would always be. I wouldn't be able to get to those court dates, and I guess just letting them fall by the wayside. I'm not sure. I don't really have any excuses.
These were just cycling for money, so that's one thing. But now you're charged with a felony. You need to show up to court.
Yeah, no, this one is a lot more serious, so I absolutely have to. I don't really have any.
On the new file, I'm going to give you a $5,000 personal bond. You're going to have court with Judge Toko.
Okay. So now you said it's a $5,000 personal. What exactly does that mean?
You don't post any money, but you have to show up to court.
Okay. So will I be getting out today?
Can issue another warrant for you and place a higher bond to where you would have to post money.
Okay.
Sir, if you don't have any other holds, if you don't have anything going on, you will be getting out today.
Okay.
For no money.
Well, that's even better. I appreciate it. And,
I'll have make sure you're in Judge Toko's court in person a week from Wednesday.
Okay. I'll have all this information as well.
We'll do a disposition sheet that'll be sent to the jail. They should give it to you when you're released if they don't ask for it.
Okay.
All right. You're all set today.
Okay. Thank you.
Thank you, Mr. Lane.
Thank you. You guys have a good one.
You too.
Here's a family member.
Am I good to go?
I'll wait for you on the hall. I'll come and talk to you.
Yep, you're good to go.
Thank you.
Your mom's here. She says she loves you.
My mom's here?
She's in the
She
courtroom.
was here.
That's crazy. I love you too, Mom. I know she came.
She heard you.
Oh man, this is embarrassing. All right, guys, you guys have a good one.
All right, Mr. Lane, thank you.
All right, have a good one.
Yeah, Mrs. Moore, who are you here for today? What's that? Oh, okay, that's where we are right now. All right. Good, glad I asked. Next matter is 24 CRB 1725, State of Ohio versus John Moran. All right, Mr. Moran, today's hearing is being recorded. Anything you say can be used against you in the future. You have a right to an attorney. If you cannot afford one, you can make an application for a court-appointed attorney. I have 2 complaints here charging you with complicities to sexual conduct with an animal. Did you receive a copy of those?
Yes.
Do you need me to read those to you?
Yeah, just to make sure.
Okay. First one states, the Licking County Sheriff, being duly sworn according to law, states that on or about April 17, 2024, in the township of Hopewell, Licking County, Ohio, the defendant John B. Moran did unlawfully, did knowingly aid or abet another in committing the offense of sexual conduct with an animal pursuant to Revised Code Section 959.21 in violation of Revised Code Section 2923.03. This offense is commonly known as complicity to sexual conduct with an animal, misdemeanor to 2nd degree. The second one is the same except for the date, which is May 2nd, 2024. Maximum penalty is 90 days in jail, $750 fine. You have any question about those charges?
No.
How would you like to plead today?
There's 2 charges here.
Yes, April and May. One is from April and one's from May.
Yeah, I'm not sure.
Okay. Would you like to talk to an attorney?
Yes, please.
Okay. You want to say anything before I set your bond?
No.
Mrs. Moore?
Yes, thank you, Your Honor. The defendant is a caretaker for several animals at the residence he shares with his partner. There are other dogs and a cat, as well as there are 60 to 80 sheep at the residence, for which he is the primary caretaker. We are asking that the defendant be prohibited from taking care of any animals at the residence. It is my understanding that Paula Evans has been in contact with his partner, Mr. Morehouse, concerning the animals. The dog in question was surrendered to the Humane Society. It is my understanding that he is willing to surrender the other dogs, the other collies, to the Humane Society, and a dog and a cat are going to leave that residence to reside with a sister, is my understanding. As far as the sheep, I guess they are
Mr.
working.
Moran is, you said?
Mr. Morehouse is working with Ms. Evans. They are working for a plan to relocate the sheep as well. So that is why we're asking that the defendant be prohibited from taking care of any of those animals. Obviously, if that plan falls through, we would then come before the court to ask that those animals be turned over to the Humane Society pending the outcome of the matter.
So how would we, if you were to be?
I would just ask for a prohibition from him taking care of any animals at the residence.
Okay.
Should we require further terms of bond on this, we would make a motion to the court.
Okay. Did you hear that, Mr. Moran?
Yeah, I did.
Okay. All right. Okay, I'll set your bond at 2,500, cash surety 10%, no contact or caretaking of any animals. You understand that?
Yes.
Okay. Thank you.
Thank you.
Next matter is 24 TRC